Mr. Townsend, we're about ready to begin. Just want to be sure you can hear me. We're
Mr. Townsend, looks like you're muted.
Yeah, Fred, we can see that you're there, but we cannot hear you. It looks like we're muted. Okay, try us again.
Okay, are you there now? Can you hear me?
Is that you, Mr. Townsend?
We're going to begin in just a minute. Our attorney is doing a web, and so we can't reach him.
Oh, okay. I was trying to bring up the WebEx, and it asked for a password after I put in the number and the access code, and it asked for a password.
You're going to put in the access code.
So I can hear you if you all can hear me.
Yes, Fred, we can hear you now.
Yeah, we can. Thank you, Fred.
Very good.
Mr. Lamb, are you able to get on through the WebEx? Mr. Lamb, are you able to get on through the WebEx?
I'm working on it right now. When I tried to log in through the WebEx, can you hear me?
Yes.
Okay. When I tried to enter the WebEx, it asked for a password after I entered the access number.
Is it able to say something like a guest or something like that? I think it's trying to log you in as the operator.
Okay, let me try again.
Are you using a cell phone or are you using a tablet or computer?
I'm on a tablet with trying to log into WebEx. I'm on a cell phone right now because when I tried to join the WebEx meeting, I entered join the meeting. All right. Get down to it here. Okay, there's an access number and then a meeting number. Let's see. I'm at the help center now. Let me get on to the. I shouldn't need to sign in, right? I should just be able to come in as a guest.
Yes, once you put that access code, you should be able to enter the meeting.
All right.
I will advise you that if you're on a tablet, WebEx usually prefers to you download their app so that you can access it through the app. Other than that, I'm not sure which browser that it's going to be defaulting you to. So if you're on a tablet, I would advise that you download the WebEx app.
Okay. No, I'm not. I'm on a laptop. I got here to the download support contract sales. I don't want to download. I just want to join the meeting. Free conferencing online meeting WebEx.
How are you accessing the link to the meeting?
I just did a Google and looked up WebEx. Just go WebEx.
Yeah, you would have to go to the county's website and the link is right there, and all you'd have to do is click on the link, and it'll take you straight into the meeting. If you go to
Just go,
calendar of events page, and then scroll down to the Board of Adjustment meeting for today's date.
okay.
Okay, all right. Mr. Chairman, I think we can begin.
Okay. Thank you, everyone, for your patience. We really like to be sure that everybody who wants to attend either way has that opportunity. So, at this moment, I am calling the public hearing to order. So welcome to the Kent County Board of Adjustment meeting for August 18th, 2022. When you're ready, will you call the roll, please?
Yes, ma'am. Mr. Nichols?
Present.
Miss Hudson?
Here.
Mr. Jenkins?
Here.
Mr. Cusick?
Here.
Miss Denny?
Here.
Thank you. That's 5 present.
Thank you. So we do have a quorum. And will you introduce the staff, please?
Good evening, everyone. My name is Jamie Fensky. I'm a planner here at Kent County. To my right, we have Scott Blair, who's also a planner. To my left, we have Mark Kennedy, our IT staff. And on the phone, we have our legal counsel, Fred Townsend.
Thank you. This time, I'm going to ask everyone to rise and pledge allegiance to our flag. Okay, so any additions or alterations to the agenda?
No, ma'am.
Okie dokie. So will you introduce the public hearing?
Yes, ma'am. So good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for purpose of providing citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 or check the Kent County Planning website to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on July 31st, 2022 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. At this time, we're going to have a brief statement by our counsel who is online this evening, the purpose of which is to help those who are going to give testimony this evening to understand what is and is not acceptable as testimony before this particular body. Mr. Townsend?
Thank you, Ms. Denny. Can you hear me?
Yes.
Okay, I'll begin. The Delaware Supreme Court established the standards for the granting of area variances in the case known as Board of Adjustment versus Quick Check Realty. The legal standard applied to applications for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. In order to determine whether exceptional practical difficulties exist, the board must weigh the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And lastly, number 4, whether failure to remove the restrictions would create an unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. The test is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business or stay competitive as a result of area limitations may justify a variance. In general, the board is not permitted to consider factors other than the ones listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the nature of the zoning district, the characteristics of the area, whether the requested variances seriously affect neighboring properties, and whether the applicant is confronted with challenges that rise to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is unable and unauthorized to resolve those disputes. Ms. Denny, that is my statement.
Thank you, Mr. Townsend. Okay, so at this point, we're ready to call our first applicant.
Thank you, Mr. Chairman. The first application tonight is A2220, Vincent F. and Janet M. Pisano. Okay, thank you. We'll call you down in a minute to give testimony after I give the introduction. So the Pisanos are seeking a variance from the 30-foot rear setback to build an enclosed porch. This property is located on the northeast side of Verona Court, 483 feet northeast of Lakshman Trail, being lot 67 in the Dover Meadows subdivision. This is west of Cheswold. It's in Levy Court District, the second, and it is zoned AR. So this plot plan gives you an idea of what's being proposed tonight. There is an existing deck there at the present time, and decks less than 48 inches are now only required by code to be 10 feet from the property line. Once a deck exceeds that height, it must meet structural setbacks. And if you'll see in the staff report here, although this deck was approved at one time, staff noticed during reviewing this application that it is above 48 inches. So theoretically, it should meet the structural setbacks, but it does not. So that's something to keep in mind when we get into discussion later on, that we need to deal with the deck regardless of whether you grant this variance or not. The variance before the board is actually enclosing the deck that is already there. And again, once a deck is enclosed to become a porch, it must meet structural setbacks. And in this case, the 30-foot rear structural setback is in place, and the The structure now is 20 feet from the property line, and when covered as a porch will also be 20 feet from the property line, which does not meet the 30-foot setback, hence the 10-foot variance request. This is a photograph of the residence. I guess this is on a cul-de-sac here to give you some idea of the character of the area. This is the front house, you can see. This is indeed the deck. You can see that it does exceed 48 inches. This is where it sits at present. This is another view of that same deck. This is an aerial photograph, again, to get some kind of feel for the character of the area and other decks on houses. And this is the aerial photograph from higher up. Okay, if we could have someone, one of the Pisanos, come up and please give testimony and tell the board about your variance request. If you could give your name and address, please speak slowly and let our attorney swear you in prior to giving testimony. Thank you.
Okay, so Mr. Townsend, Mr. Paisano is at the microphone, and he's going to give his name and address, and then he'll be sworn.
Name is Vincent.
Thank you. I can't see him. Mm-hmm.
He can't see you.
Go ahead, sir.
Oh, okay.
He doesn't have to. On his eyes.
Gotcha. Vincent Pisano, address is 89 Verona Court, Dover, mailing address 19904.
Mr. Pisano, do you solemnly swear and affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed. And I can see the chambers. I can see Mr. Pisano clearly at the podium.
Oh, okay. So at this time, you're going to tell us what you're trying to do and why, and then we get to ask you some questions.
Okay, fine. Presently, we have a deck that's on the back of the house, as you can see in the photographs that were there. And what we're looking to do right now is just to put a roof over the top of that and screen it in. That's the extent of what we're trying to do. And then we come to understand that there's a setback. Well, our backyard is trees. So our neighbors to our left and to our right really don't see our backyard per se. And that's where we're looking for a variance to, I guess, for that 10 extra feet.
Okay, and so also, as they were out and investigating for this application, I'm sure they've explained it to you, they find that your deck is higher than it should be according to the code. Obviously, as we look at this photo, we realize that it's where the entrance to and from the house is. I mean, it's on level with those. But so my first question is, did you have a permit when you placed the deck?
Okay. Let me
Okay.
go. That deck, as you see it right now, was installed by the previous owner, and there was a variance that he obtained for that, and that was under deck permit 065399, and it was SL 9618. I have that report that was obtained, and that
Okay.
Alan Springsteen was the previous owner, and the levy court at that time, I'm trying to find the date here, March 8th of 2007 is when
Okay.
that variance was permitted. So,
Okay.
Yes, if I may interject, yes, this was indeed permitted, this deck, and the fact that the height exceeds the 4 feet, I mean, it was still permitted. And he actually needed a waiver from wetlands. The previous owner needed a waiver to build that deck there. It wasn't a variance per se like the setback tonight. So all that was granted for the deck, so.
Because the deck would have, without a roof, without the rest, would have been according to code. And of course, as Mr. Paisano stated, what's on the other side of of those trees is wetlands, and as we saw in the picture, not really pretty. Okay. Does anybody have questions of Mr. Paisano?
Yeah, dude. Can you just describe the reason why you wanted the screen porch? Just any hardship shade?
Well, I'm
and
not quite
raisins
sure
or-
what you understand by hardships, but let me explain why hardship is for this particular reason. It's a swamp in the back. And so when we like to sit out there in the summer months, we're swamped with mosquitoes, snakes, frogs, turtles, and all other kinds of wildlife. So screening in the porch and being up there would be beneficial to my wife and I and our family visits to not get attacked by all the bugs in the area. That's the only reason putting a screen around it. So need a roof over the top of that. So it's a nice area to be back there.
Thank you.
Does anybody else have questions or comments?
Yes, I have one. Mr. Pisano, you had mentioned that the neighbors can't see your backyard, correct?
At the present time, if you look, right, the two houses, one on the left, one on the right, to the backyard, unless they're further in the back, and if you look at the property lines, they'd actually have to be on my property to see my backyard.
So adding a roof and screening that in would not really block the views of either neighbor on each side, in your opinion?
That is correct. There would not be any visual obstruction to anybody.
Okay, thank you.
Okay, and have you ever had any complaints about the deck as existing or with the sign up now saying something's going to happen? Has anybody objected?
No. No complaints, no comments, nothing.
Okay. So anybody else? That's it. You can be seated.
Thank you. Thank you for your time.
Thank you, Mr. Pisano. Is there anyone else in the room who would like to give testimony in favor of this application? In favor? No. Anyone online, Mark, that would like to give testimony in favor of this application?
If there's anyone joining us online by phone, you can press *3 to raise your hand if you would like to give testimony in favor of this application at this time. I see no hands raised.
Thank you. Okay, no more in favor. Is there anyone in the room who would like to give testimony in opposition to this application? Opposition? No. Anyone online who would like to give testimony in opposition?
Similarly, if you would like to give testimony in opposition and you're joining us online, press *3 to raise your electronic hand and we'll let you into the meeting. No hands raised at this time.
Thank you. Hearing no more testimony in favor and opposition, I declare application A22-20, public hearing closed.
Next, we have application A-22-21 for McLam. Is there someone present for that application? Thank you. All right, so the applicant here is Deborah McLam. The owner is Randy McLam. Present zoning district is AC and RS1. The proposed variance is a variance from the 75-foot front setback from a major roadway to legalize a porch. Present use is residential, proposed use the same with an extended porch. It's in Levy Court District 6 for Mr. Howe, located on the west side of South DuPont Highway, approximately 0.17 miles south of Midstate Road, east of Felton. Here you will see that the porch extension is at 72.5 feet from the front property line. Again, the required front setback is 75 feet, so they are asking for a 2.5-foot variance. Here's looking down the road, down the highway, and further south. This is looking at the porch extension, so this was already installed and it is there. This was found and brought to our attention through a violation, code enforcement violation. This is looking from the side of the property, kind of the side at the front porch, and again at the front porch, from the other side of the house, and the aerial. So Ms. Lamb, if you would like to come forward, state your name and address, and allow our attorney to swear you in.
Hi, I'm Deborah McLam. Address is 11610 South DuPont Highway, Felton, Delaware.
Ms. McLam, do you solemnly swear the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Did my brother want to speak first before me? Okay.
Could you speak up a little bit, please?
Yeah,
Oh, I'm sorry.
pull the mic
The mic a
maybe
little-
to
pull
you
the
a
mic
little
bit
bit.
closer.
Okay. Oh, okay. Is that better? Is that okay? I'm here, of course, because of, I did put the porch up and wasn't aware that I had to have something I was told was wrong. So I added and the reason was the original porch that was there, it was not usable. It was actually hazardous. When we would come outside, I fell several times myself. I have a handicapped child, which needs assistance walking and everything. It gets extremely slippery in the winter, or like if we have a bad rain, the leaves come onto it. Like I said, there is no covering at all. Mosquitoes are horrible there. It just was not a usable porch. So basically, for the safety of especially me taking care of a handicapped child, it was just treacherous. Now that we've put the porch on, it has stopped all the water and all the debris and everything coming to the porch. So it's made it just much more usable for us to be able to come out and feel safe out there and be able to walk out there. So that's the reason, we want to be able to keep it, and I'm praying you will let me keep it because we work very hard to make this usable for the home.
Okay, so I usually let them ask first, but I'm going to ask a couple questions. So when you testified that there was an existing porch, but it had become dilapidated and problematic. So now you established this porch, not realizing, it sounds like, that you would have had to, once it came down, you had to have a permit to put it back. But aside from that, does this porch that you have built, is it the same footprint, the same dimensions as the porch that came down?
Well, we didn't take the porch down that was there. It was basically the porch that was there. There was no covering around it. It was just totally open. So everything that came in, from rain to snow to ice, it was on the porch. It sat on the porch. So we built an extension off of that porch, 4-foot extension, and put the screen around it. So that kept all that out. So we don't have all that debris on our porch anymore. And my little girl's handicapped also. Like I said, she's homebound. She's schooled at home because she's too sick to go to school. Just everything I do is around her. I don't mean to get emotional about it, but if I have to take it off.
It's okay.
You understand?
That's okay.
That's
we
why I put it
understand.
on.
There was an existing porch, and you built it further out. There was a roof on the existing porch.
Yes.
And was it screened in?
No.
In the beginning?
No.
So it was an open porch, and there was a roof over. And did you extend the roof line?
Yes.
Okay. And without the whole reason you're here is because it was done without
Without their permit.
a permit?
Yes.
Okay. All right. Anybody have questions for this lady?
Yes. So if I'm following you correctly, the 4-foot extension put you in violation. Is that correct?
Yes.
Okay. Thank you.
Are any of your neighbors' porches, do they stick out just as far?
Yes,
Or-
so the house that's next to me, my porch actually meets the home, where it's actually in line with that home. The new porch is right in line with the home that's next to me. And it's the property that is commercial.
So you would say it's in character of the surrounding area? It's not like a stick out of like a sore thumb?
No. I actually have had a lot of compliments on the porch. I had a lady that stopped there after we had put it on, and she got very teary. She said her dad built the home. And she was just like, wow, it looks so amazing. So, yeah, all my neighbors just happy with what I'm doing there, because the home was pretty in bad shape when we bought it. And I'm trying to just make it, livable and a nice place. Like I said, a lot of things that I do there is for my little girls, so.
Anyone else, please?
Yes, one more question. What year was that transformation done or extension done?
2020, I'm sorry. That's my daughter with me, and I couldn't remember. It was 2020.
2020?
Yes,
Okay.
sir.
All right, thank you.
Ma'am, did you do the construction yourself or someone in the family? You hired
I hired somebody to do it.
and they didn't inform you that you needed to have a permit or look into the county code? Okay, thank you.
Anybody else?
Yeah, I have one. So one of the comments from the staff were like safety concerns, just with vehicle traffic. Obviously it's been built for 2 years now, so any issues that you've seen safety-wise with the vehicle traffic along 13?
No, not at all.
And as I'm viewing this, it appears as though there's zero obstruction of view if there's any cars coming back and forth on that roadway. You're so far back that the risk of somebody pulling out, and your view when you're at the end of your drive, pulling out, you have full view.
Oh, yeah.
both
When we moved in
directions.
there, we didn't. It was terrible. I had to take them out. But we had big, huge bushes out there. And I used to have to ease out just to look at it. As a matter of fact, we had an officer that would actually sit back and he would catch, because they have the speed entrapment there, and he would sit back behind the bushes in the neighbor's yard. And I always used to wave to him and talk to him. He said, yeah, he's been sitting there for years. But we took it out because I always had a hard time getting out of my yard because of the bushes. So we took them out so we could have full view of pulling out and everything.
Okay, and so, and I don't want to get you upset again, but I just want,
I'm fine. It's
That's
just we
okay.
work
It
so
is
hard with
emotional and it's
everything.
frightening. It's just nervous to be in front of this body. So ultimately, this porch is part of your everyday life, and it protects, as you in your testimony, from slip sliding, from weather elements and things, making this a more dangerous ingress or egress from your house as a pedestrian, and multiply that by the fact that you have a handicapped child. Okay. All right. Anybody else?
Yes, one more. How long have you owned this particular property?
How long?
Yes.
It's 2014. The end of 2014 we bought it.
Okay, from 2014 to the present, if you consider the previous question about traffic, what would you say the traffic is like in that general area? I mean, do you know of any history of problems in that general area?
Other than police officer making people go slow and doing the speed limit, because we have them sitting right out in front of our house and they're constantly, slowing them down. But no, I haven't seen anything really.
Okay, thank you.
Okay, so I'm going to hit you with one more. Hopefully that will be it. So in your testimony, you hired someone to build this, and that person, that contractor person, made you aware or told you that it would be legal, that you didn't need a permit.
He never told me I needed a permit.
Okay.
He never said anything about needing a permit or anything.
Okay, all right.
And I guess I'm ignorant on that part where I didn't know, and if I had known, I would have went and got one. I just
Certainly.
was trying to think of something to do to make it safer out there, and also somewhere where she can come out and not feel like she's so secluded in the house all the time. If it's raining, I can still take her out on the porch, and she can have somewhere besides the four walls that she lives in all the time. It's just, I work around her little world. She's my great niece. Her mother passed away, and I've had her for ever since she was a year old. And she's 13 now, and she just started walking last year. She still needs assistance, but she's getting there. So,
Well, good for you. Okay. All right. Going once, going twice. Anything else? Thank you.
thank you.
Is there anyone else that would like to speak in favor of this application?
Yes, we do have somebody that's online. Yes, Mr. McLam, if you can unmute your line by pressing star 6, give your name and address for the record, and be sworn in by our attorney.
Okay, can you hear me now?
Yes, sir.
Hello?
Yes, you can proceed.
All right, my name's Randy McLam, and I'm the registered owner of the property. I purchased it from my sister.
Mr. McLam, can you give us an address, please?
My address here is 6 Twin Springs Drive. It's in Dalworthington Gardens, Texas, 76016.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed with your testimony.
Okay, I just wanted to address the safety concern. We've done some of the measurements, and the county Exhibit A stated that the request was a variance of 75 feet from the roadway, whereas actually we've got pictures from the Google map and everything. The distance actually from the roadway is 90 feet, not 75. There's an 8-foot 10-inch shoulder from the edge of the road to the front lawn, and then from that front, where the front lawn, which is what we would think would have been the property line, because since we've been maintaining it for all these years, we didn't find out until later that 8 foot and 8 inches into the lawn area where the utility easement is where that 72-foot measurement comes, 72.5-foot measurement comes from. So it's actually 8 foot 8 inches into the lawn, 72 feet, or actually 90 feet from the road. So I just wanted to make sure that that was clear. And we also have trees in the front, and I would believe that this, if there was worried about people veering off and running into the house, that porch would actually be more protection for the main house than less. So I just wanted to express that as that the safety factor here, I think, is actually better for the home than it is before.
Thank you, Mr. McLam. Does anybody have any questions for Mr. McLam?
I've got a question of staff. The measurements listed here, 75 feet. Apparently, this easement isn't taken into account. Is that correct?
So there's some confusion here. The front property line is not the road. So his front property line is close to what you're seeing on the screen. So his front porch is about 72.5 feet from the front property line, and that's finding the marker and measuring it back. They do not have a survey of this property, so that was the best we could work with, is finding the survey marker and measuring from there, but the front property line is not the road.
So it says at the top on Exhibit B, variance from the 75-foot front setback from a major roadway to extend a porch. Based on this testimony, it would appear that if you take into account the easement that was granted for the utilities, as I heard it would be further from the roadway than 75 feet. Is that accurate?
No, sir. So the utilities are on the other side, or in the right-of-way, that grass strip, if you see to the right of that yellow line.
Yes.
So that's the utilities where they go in the right-of-way.
Accurate, but my question has to do with the setback from the roadway. You're not measuring the setback from where the utilities are sited, the easement. You're measuring and determining whether or not it's far enough back from the roadway to the front of the property. Is that correct?
No, sir. From the front property line to the porch. This
from
has
the
nothing to
front
do
property
with the
line
roadway.
Right,
So essentially, I think what they're trying.
but that's not what Exhibit B says. Exhibit B says setback from a major roadway.
Because
It's a major roadway?
It's a major roadway, so that setback, so a normal setback for a residential is, say, 25 feet. I just
40.
threw a number out there, 40 feet, yeah. But since it's a
Either I'm
major
not making
roadway-
myself clear, or I don't understand. Either way, let me delve into this. Please, go ahead.
So like Mr. Cusick is trying to explain, the highway there is a major roadway. So that has a higher setback. If this was on a back road that was not well-traveled, it would only have, with this zoning, it would have a 40-foot setback. But because it's a major roadway, our code enforces a 75 over that 40 because it is a major roadway.
But am I correct or incorrect when I look at this exhibit that you're not counting the area in front of the,
Yeah, they don't count to the
Property
road. If
lines,
you
you
were
don't
to
count.
measure from the asphalt to the porch, it's 95 feet. But they're measuring from the yellow line. But you're right. So if they measured from the road, it's 90 feet. But if you measure from their property line, it's 72 feet.
And so essentially, testimony from our planners was that they located the stakes, and so they measured back from the stakes, from the stakes from the original survey of the property.
I think I'm clear on all that. I'm still looking at what it says. 75-foot front back from a major roadway. It is more than 75 feet from a major roadway, is it not? I understand it's 75 foot to the property line, but it is farther than 75 foot from a major roadway.
No, the major roadway is making that 75-foot setback.
But they considered the right-of-way a part of the major roadway. So that would be considered a shoulder of the major roadway. So the roadway goes to the telephone lines, and then from the telephone line.
So
Right,
essentially,
you're ignoring the fact that the easement exists, is what I
an easement
understand
exists
being
for the
said.
for the right of way for the
utilities.
like for utilities and DelDOT or whoever. But essentially, what we're looking at is what the county code defines, and we go by those stakes, and we call that the front marker, and then from there back. And so on one side, it appears as though everything's good, and on the other side, they're a little bit askew. And also, to me, the house itself is a little askew, which is very typical of many properties in Kent County, probably throughout the state, but that's how it tends to be.
I think I'm clear.
You got it? Okay. Anybody
Okay, I would
else?
like- Yeah, can I, where you're at,
Mr. McLam, is it you? Are you trying to speak?
Yeah.
Sure.
yes, I'm just trying to get clear, that was one of my questions.
You're
was-
breaking
in-
up. You're breaking up a little bit, so maybe go a little slower because we need to have it's important what you want to say.
Oh, okay. The gentleman there that was asking the question, this is the same question I had posed previously, was a 75 foot. If the 75 foot is from the roadway, if that's what we were trying to protect from versus, from the property line, which, we discussed this previously, is, if the house was 5,000 feet in the property line from the road, I think I asked this question before, then you're telling me that the property line to the house would be too close, and the house is sitting, 5,000 feet off the road, but the property line to the road is all considered to be right of way. And I've asked this question before when this was all brought up, and what I was told is yes, that's correct, that would all be right of way, and it has to be 75 feet from the property line. So the question he posed here to me was valid and something I had asked a question about before. So I just want to make that clear.
Yes, and I understand the point you're trying to make, and Look, we do this. I've been doing this for 22 years. And I also participated when they wrote when these codes came into play. I'm older than dirt. So I fully understand what you're saying, and so we get it, but also there's a huge difference, like we call this Del Dot right away, utility right away, and it can be very confusing to people. And so certainly, believe me, you are not the first application of this nature we have heard for exactly the same reason. You look out of your front door, you buy a house, and you think, oh, wow, I own all the way down to the end of my driveway, but maybe not so much. And so essentially, what the county weighs, what we look at and what we are weighing is those property marker stakes that are at the front of your property. And that's where the county ruler measurements begin. But I fully understand what you're trying to say, and I do realize that this was like kind of an honest mistake. I get it. So just want to assure you there's no judgment here, okay?
Okay. Thank you.
Anybody else?
I see no more hands raised online at this time.
Well, I'm not sure that, I can tell you have a question, and I want it answered.
I'm sorry, I do have a question, and I only want the question answered in relationship to what matters we can rule on. At the beginning of the hearing, the Board of Adjustment's Quick Check Realty case explains the basis we have to follow in order to make decisions. It also explains that we can't get involved in any disputes that you might have. Staff indicates that, however, so I'm only interested in this as it pertains to the four quick check issues factors that we can rule on. But staff indicates that this was an enforcement issue that brought this to Kent County's attention. So in that regard, the only thing I'm interested in as it pertains to these four factors is whether or not this enforcement issue that was brought to the attention of Kent County should weigh in our decision-making process. And so let me repeat them to you again, and then I'd like you to tell me whether or not they do or they don't. The factors that we can rule on: the nature of the zone where the property lies, the character and uses of the immediate vicinity, whether or not removal of the restrictions on the applicant's property would seriously affect neighboring properties, and whether the removal of the restriction would create unnecessary hardship or exceptional practical difficulties for the owner in relationship to the owner's efforts to make normal improvements. Now, those are the only four factors that we can consider. So is there anything about this enforcement issue that pertains to those four factors that we should consider in determining whether or not to grant this variance?
Ms. Denny, this is Fred. Could I speak to that?
Absolutely. I was just going to say we're going to ask Fred to answer this.
Mm-hmm. So, as you correctly point out, the four factors are the ones that are listed, and nowhere does it ask how it was that the existence of the problem was arrived at, whether it was through a complaint from a neighbor or whether it was by virtue of a inspection that related to some other project being performed on the property. If a neighbor had an objection to the improvement, they would have had an opportunity to be heard tonight and make the case that the removal of the restriction significantly impacts them in some way. And I suspect the hearing's not closed yet, but we'll wait and see whether anyone does. But I don't think there's any other significance to related to how it is that this violation or the existence of this improvement violates the code is not relevant to your examination of the application.
Well, the only, to your point, whether the removal of the restriction on the applicant's property would seriously affect neighboring properties. I'm not going, if there is someone who objects to this application, we'll have a chance to hear them. I would like to know, since I'm not going to have an opportunity, Mr. Townsend, to speak to the applicants again, whether or not they're aware of whether removal of restriction on the applicant's property would seriously affect neighboring properties. So that really is my question, but I wanted to list all 4 reasons to put it in context. So, but you're right, there's only one that I'm really concerned about. So to the extent, may I ask, to the extent that it might affect, are they aware of any removal of the restriction on their property that would seriously affect neighboring properties? That's the only thing I want to know. Nothing else is relevant.
So that's a perfectly reasonable question to ask of Mr. McLam, who is, I think, still in the midst of his testimony.
I wanted to preface it by saying I'm not interested in property disputes or any other matter that may exist other than that one issue, which that's why I made it a point to repeat what you said earlier. But thank you, Mr. Townsend.
So, Mr. McLam, can you hear us?
Yes, I can.
Okay, so obviously you have been listening to this conversation between our board member and the county attorney. And so the question is, and would you like to ask the question?
Whether removal of the restriction, or to the best of your knowledge, are you aware whether removal of the restriction on the applicant's property, which is, the applicant, I suppose, here is you, would seriously affect neighboring properties? Are you aware of any issue that the board should be aware
of? To the contrary, the neighbors have, the person that made the complaint is no longer there. He was renting the property next door. He's gone, and the neighbors who actually own the property have commented on how much it has improved the property from its original state and actually brought up property values, so they were very pleased with it. So no.
Thank you.
Thank you so much. Okay, so now, that's important to me too.
I knew I was treading on thin ice. That's why I wanted to be.
It's important
that I made myself clear that I was only interested in these 4 matters, and in particular, the one issue that we just resolved.
And that's
and it's resolved. Thank you.
Okay. Anybody?
Thank you.
Okay.
Is there anyone else that would like to speak in favor of this application? Is there anyone that would like to speak in opposition of this application? Seeing no one, we will close the public hearing for application A-22-21.
Okay, the next application for this evening is A22-22, Herbert T. Reynolds III and Julie P. Watson. Is there someone here tonight to represent this application? Please just raise your hand. Thank you. We'll call you up in a second. Mr. Reynolds and Ms. Watson are seeking a variance from the requirement that an accessory structure used for a home-based contractor establishment be set back from the public street right-of-way a minimum distance equivalent to 30 feet beyond the rear elevation of the main dwelling on the premises to enable a home-based contractor establishment. This property is located on the east side of Robbins Road, approximately 0.17 miles south of Andrews Lake Road, west of Frederica, Levy Court District 4th. The zoning district is AC. So this gives you an idea of the location of this proposed pole building. Now, as the board knows, normally a pole building used not for a home-based contractor merely has to be 5 feet from the rear and side property line. If it is placed in front of the dwelling, it must be 100 feet from the front property line. Because this pole building is being used for a home-based contractor business, the setbacks are different. The property line setbacks are 15 feet, and there's also the provision that it must be 30 feet beyond the rear elevation of the primary dwelling on the premises. Because of the way the house is located on this large parcel, if we can go to the next slide, please. This gives a better idea. This is the area behind the rear elevation of the house that will be required to meet the 30 feet. As you can see, the property lines have been, or setback lines have been placed. The 15 foot from the property line is in green, and then the 30 feet beyond the rear elevation of the house is also shown, and you can see that forms a rather narrow triangle there, and trying to fit the pole building into that could, possibly create a practical difficulty, and that'll be your judgment as to whether it does. If we can go to the next slide. You can see this is just giving you the character of the area up and down the road. This is a view of going back to the site. As you can see, you cannot see that from the road with the tree line. You come back, and there is the existing pole building that will not be used as part of this home-based contractor in the back. As you could see by the previous slides, the proposed building will be off to the left of that, and you can see to the right there is the existing dwelling, of which the contractor pole building would have to be 30 feet behind that rear elevation. It's another photograph to give you an idea of the size of the property. More of the buffering trees there. Again, this is the entrance to the property. And this is an aerial photograph. You can see the property, the existing pole building that gives you an idea of what's around, the character of the area. You can see other pole buildings in the area on other properties as well. And this is a higher elevation, again, to kind of give you an idea of the character of the area. Okay, if we can have one of the applicants come up, please, and please state your name and address slowly, please, and allow our attorney to swear you in and give testimony. Thank you.
My name is Herbert Reynolds, and we live at 704 Robbins Road, Frederica, Delaware, 19946.
Mr. Reynolds, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Okay, so it's your turn now to tell us what you're asking us and why.
Sure. So with the aerial photo in mind, with the home contractor, we have to be within that 30 feet from the rear of the house. Unfortunately, the house was kind of placed at the rear of the property. There's no really good place to put that pole barn. I mean, you'd have to count the setback of 15 feet from that 74.5, and there's just no room. There's also a wellhead, not in the aerial photos that you can make out, but actually right where that blue line is on the back line there is actually like a creek or a ravine. So even if we added a pole barn there, the water runoff would just add more to it. Other than that, the other side is all wetlands, and something you can't notice is the back of the property actually slopes. So you'd have to bring in massive amounts of dirt if we were to try and place it to the my left of the house. But the pole barn itself, we're trying to put next to the garage, along the property line to our other neighbor there behind us. She has started planting trees prior to us being there, so that's actually an old photo. So you can't see the trees in the photo, but they're not mature yet, but within years they will be, and that will block the view from Andrews Lake Road looking in as well.
Does she currently have a pole shed there as well?
Yes, yep. Mm-hmm.
So essentially, this pole shed is going to be used as part of your business?
Correct. Mm-hmm.
And what type of business would this be?
We own a restoration shop for cars from the 60s and 70s, so we'd be restoring and maintaining cars from that time period.
Okay, so essentially, you're going to be running like a business from, it's like a home business from
Yes.
this building. Okay. Okay, anybody else?
When you said home business, you're not going to have hundreds of people a day. It's like one or two clients here and there.
Yeah, it's one or two a week. Yeah.
Okay.
If I may, Ms. Hudson, yes, that's correct. Pending on the variance approval, the next step is to be approved as a home-based contractor, and one of the provisions in there is all storage must be within a building, hence the need for this building.
Okay. Anybody else?
Yes, I'd like to see the projected location of the building from one of the aerial shots, if it's possible. Okay.
Going in front of the existing building that's there.
Okay.
Yes, yeah, it's 50 feet between it would be 50 feet between the two buildings.
If you want, you can use that screen and kind of point it out. If
Another,
it's,
the survey picture with the red drawing, is that one? There we go. So if that helps answer your question. I'm not sure how to work this thing, but yeah, so you can't see any of our property from the roadway, from the front where the mailbox is, but that would be looking at the house to your left.
Thank you.
Have you heard of any objections from your neighbors regarding the construction of the building? Anyone approached you about it? There's a sign out there. Anyone say anything?
Two neighbors stopped by. One was curious about what we did and actually had a older car that he questioned us about. Kind of cool. The second neighbor was the one with the matching pole barn, and she just wanted to make sure that no water runoff or anything like that would be affecting her property, to which I talked with the builder, the pole builder, and he assures there will not be, because there's no elevation of land being happen.
Thank you.
Anybody else?
Oh, one additional question. What's going on to the rear of the house? Is that an open field or what's going on?
It's a farm, yes, a farm.
Okay, thank you.
Okay, anyone else? Thank you.
Thank you.
Thank you, Mr. Reynolds. Is there anyone else in the room who would like to give testimony in favor of this application? In favor? No one? Anyone online who would like to give testimony in favor?
If there's anyone that's joining us online and you'd like to give testimony at this time, please raise your hand and we'll be let into the meeting. See no hands raised at this time.
Thank you, Mark. Is there anyone in the room who would like to give testimony in opposition to this application? Opposition? Anyone on the phone line who would like to give testimony in opposition to this application?
See no hands raised at this time.
Thank you. Hearing no more testimony for or in opposition of application A22-22, the public hearing is now closed.
Okay, so what's your pleasure? Shall we just reopen, just go ahead and open the business meeting and do this, or does somebody need a break? Okay, so at this point, I'm going to call the business meeting to order. And even though no one has left, would you please call the roll again?
yes, ma'am. Miss Hudson?
Here.
Mr. Nichols?
Here.
Mr. Jenkins?
Here.
Mr. Cusick?
Here.
Miss Denny?
Here.
That's showing 5 still present.
Thank you. First order of business is the minutes from last month's meeting. So I would need a motion and a second.
I'll make a motion to approve the Board of Adjustment minutes for the July 21st, 2020 Board of Adjustment meeting.
Second.
So we have a motion and a second. All in favor?
Aye.
Aye. Any nays? Okay, having received unanimous positive votes, the minutes are hereby approved. Next order of business is the notices of decision. which are A2209, A2219, A2218, and A2217. And so I would need a motion and a second on that. I just want to look at the one because I want to be sure I have. I think A2124, that's Cox. So that's still a decision we're trying to,
No, that will be an extension.
An
So that's
extension.
an old business item we have to.
okay. All right. So,
I make a motion that we approve the notion, or the decisions of A22-09, A22-19, A22-18, A22-17.
we have a motion. I need a second.
I'll second that.
Motion a second. All in favor?
Aye.
Aye. Any nays? Notices of decision A2209, 1918, and 17 are hereby approved. Okay, next order of business is old business, which we usually don't have, so I'm like, what? And that is application A2124.
Thank you, Mr. Chairman. I'll set this one up. So this, again, you're correct, this A21-24 Cox. So this variance was approved on July 15th, 2021. The board voted to grant a variance from the 75-foot front setback to 64 feet to construct a dwelling. So what happened in the previous year, almost a year, is the applicant has had trouble trying to get construction documents and funding and some other miscellaneous things that has held them up, and they do not feel they would meet the one-year variance deadline. So they're before the board tonight asking for simply a one-year extension. Their feeling is they can get all the necessary construction documents and secure funding this fall and begin construction. So again, just to be safe, they're requesting 1 year to make sure they don't go past the 1 year extension. So that's what's before the board tonight.
Thank you. So everybody understands. Okay, so at this point then, I'm looking for a motion to extend for 1 year the
I'll make a motion.
variance application for A2124.
I'll make a motion to grant a 1 year extension for application A21-24 for 1 year.
Second.
So we have a motion and second on that one. I think we should call the roll.
Yes, ma'am. Ms. Hudson?
Yes.
Thank you. Mr. Nichols?
Yes.
Thank you. Mr. Cusick?
Yes.
Thank you. Mr. Jenkins?
Yes, per my motion.
Thank you. And Ms. Denny?
Yes.
Thank you. That's 5 in favor of the motion.
Having received unanimous positive votes, there is application A2124 is granted a 1 year extension. So, moving right along, we're going to deliberate on the applications before us tonight. It appears as though everyone is still here. And as we move forward, I just want to make note of the fact that I do know Mr. and Mrs. Paisano very well. As members of my church, see them frequently, practically daily. And that said, I feel no need to recuse myself because my friendship with them at this point, as the way it is, would not influence my vote one way or the other.
Mr. Townsend, do you have any opposition of that?
I do not. I think that Denny's explanation is sufficient.
So we should just, again, we're all together, so we'll start and go down the line again.
Well, I think that property is unique. It's definitely not a regular shaped property, and there's no one behind them, so it wouldn't seriously negatively affect neighboring properties.
And I certainly agree with that. And as I looked at this application, and understanding that this deck existing was built prior to this ownership, and you know, from a point of exceptional practical difficulty, you know, when your house backs up essentially to a swamp and you're living in Delaware, just as a matter of what was suggested by the applicant, is you have not only bugs, but snakes and other things, and you should be able to enjoy what's left of our outdoors these days. So that's my statement.
I'll make a motion to approve application A22-20. There's no impact on, per the testimony, there's no impact on the neighboring properties. It backs up to heavy forestry and the unique property line. I think the hardship is there for this applicant to be able to improve his dwelling in the right way with the bugs and stuff backing up to the wetlands there.
Second.
Can I just, my understanding of the notice from the planning department was that as we made a motion one way or the other, that we should include, just as a matter of housekeeping, the fact that this is 4 feet above
But
grade.
if we approve this, it doesn't really matter.
Doesn't matter.
No.
Okay. All right.
Okay, so Mr. Nichols?
In connection with A22-20, I recommend that we approve the application. Failure to approve it would create an exceptional practical difficulty for the owners.
Thank you. Mr. Jenkins?
I vote yes in support of application A22-20 based on the testimony of Mr. Pisano and the two things that he pointed out. First, there would be no obstructions by the neighbors with this closed-in porch. And the fact that there's wetlands right there behind him, all that wooded area.
Thank you. Ms. Hudson?
For A-22-20, I vote to approve based off public testimony and the property backs up to wetlands. There's true hardship with the mosquitoes and snake property backing up to the wetlands. And I feel the removal of the restriction would not seriously affect neighboring properties.
Thank you. Mr. Cusick?
I vote yes per my motion.
Thank you. Ms. Denny?
I'm going to vote yes. I absolutely see an exceptional practical difficulty here based on the backing up, the way it's backed up to these particular wetlands. And that's not to set a precedence that every property that backs up to wetlands is an exceptional practical difficulty, but in this case, and with the testimony given this evening, it is. So, yes.
Thank you. That's 5 in favor of the motion.
Having received unanimous positive votes, application A2220 is hereby approved.
Next, we have application A-22-21, seeking a variance from the 75-foot front setback from a major roadway to legalize a porch.
Any thoughts or discussion?
Well, I feel this property is in character of the surrounding areas. I don't see how the porch makes it different, and I don't see how the porch would obstruct any views or seriously affect the neighboring properties.
If this application is approved, the owners would, this question of staff, would have to get a building permit and notify county that it's been legalized. Is that correct?
Yes, sir. So they actually have applied for the permits to get this taken care of. That's where we found the variance. So the permit application is in, It's just waiting on zoning approval if you guys grant approval tonight.
So if we approve it, we don't have to make it contingent upon them submitting an application since it's already in, correct?
Right, we'll still put on there that they have 1 year to pull the permit, but they are in current violations, so the code enforcer will keep upon them.
Okay, thank you.
Anybody else discussion, or can I get a motion?
I'll make a motion for A-2222. I vote to approve based off based off public testimony that we heard tonight. I believe that property is truly unique, being on close to a major roadway. Everyone's property is constantly being eaten up by the major roadways. Am I on the right one?
It's A-20.
Oh, I'm sorry. Hold on. Yeah. Based off the public testimony, and I believe removing the restrictions would not seriously affect neighboring properties, and it would be within character of the surrounding area. And I believe the porch is actually in line with the neighboring properties, so it would not stick out.
Second.
Okay, so we have a motion, a second. When you're ready, will you call the roll?
Thank you. Mr. Jenkins?
I vote in support of application A-22-21 based upon the testimony of Mr. McLam clarifying the distance and the whole safety issue. For me, that gains my support.
Thank you. Mr. Nichols?
I vote to approve A-22-21. I find that it's in character of the zone where the property lies, and failure to remove the restrictions would create an unnecessary hardship and an exceptional practical difficulty for the owner.
Thank you. Mr. Cusick?
I vote yes for application A-22-21. I think it fits within the surrounding properties as well as per the testimony given tonight. The hardship for them to be able to create a space that's hazardous free for the family.
Thank you. Ms. Hudson?
I vote yes per my motion.
Thank you. And Ms. Denny?
I'm going to vote yes. I see an exceptional practical difficulty here because this certainly is a normal improvement to a house. And in light of the fact that, adding to the fact that they have a handicapped child who needs to be able to have some freedom out front, this is necessary. And so, not to set a precedence, but I am going to vote yes.
Thank you. That's 5 in favor of the motion.
Having received unanimous positive votes, application A-2221 is hereby approved.
Next, we have application A-22-22 for Herbert Reynolds and Julie Watson. The variance from a requirement that an accessory structure used for a home-based contractor establishment be set back from the public street right-of-way in minimum distance equivalent to 30 feet beyond the rear elevation of the main dwelling on the premises to enable a home-based contractor establishment.
Okay, any thoughts or discussion?
I'll make a motion to approve application A-22-22 per staff recommendation and the hardship that these setbacks create. This unbuildable triangle for them to build a pole barn for their home-based contractor, and then where they're putting it is a logical location.
Second.
So we have a motion and a second. When you're ready.
Thank you. Mr. Nichols?
In connection with A-22-22, I vote to approve the application. I find that it's within the nature of the zone where the property lies. I support staff recommendations, and I feel that failure to remove the restrictions would recreate an unnecessary hardship or exceptional practical difficulty for the owner.
Thank you. Mr. Jenkins?
I vote yes in support of application A-22-22 for two reasons. First of all, the testimony of the applicant, and two, it seems to be an exceptional practical difficulty when you include the wetlands and the Blue Line stream. It makes this very challenging to accomplish. So.
Thank you. Ms. Hudson?
For A 2222, I vote to approve based off the staff recommendation. The property is unique, the layout with the well and the wetlands, and I believe that removing the restriction would not seriously affect the neighboring properties.
Thank you. Mr. Cusick?
I vote yes per my motion.
Thank you. And Ms. Stenny?
I vote yes. I do see an exceptional practical difficulty because of the shape and boundaries of this property and what they are trying to accomplish, and also knowing that they have that the business itself is going to have further review by a different body. So yes.
Thank you. That's 5 in favor of the motion.
Okay, having received unanimous positive votes, application A 2222 is hereby approved. The only thing I'm looking for now is a motion to adjourn.
Make a motion to adjourn.
A second.
All in favor?
Aye.
Aye.
Good night, everyone. Thank you.
Thank you, and thanks for accommodating my request to attend virtually.
You're so welcome. Have a good night.